So whenever we talk about specific relief act, you all should remember that for understanding specific relief act, you need to understand few basic definitions. For example, you should all know what is the meaning of property. You should all know what is the meaning of immovable property. And when I talk about immovable property, I have already told you that just go through the videos which I have shared on the YouTube channel regarding the specific effect. So when I talk about immovable property in particular, you all should remember that this definition is very well defined in Indian Registration Act. So you must know the definition of immovable property. You should know what properties are immovable. For example, standing timber, what is the nature of that property? Because in prelims exams, you will normally put up objective questions regarding the identification of the property, that which is the property which whether what is the nature of the property. So when you talk about that kind of you know uh, yeah, when you talk about that kind of question, you should know what is the nucleus of that. So for understanding specific relief act, you should all remember that specific relief act is a special remedy. Normal remedy was always given in civil law, right? So normal remedy was always sued for damages. Because if you remember, whenever we do specific relief act was not there earlier, and it came wide section specific relief act 1963, and now the major amendment has happened in 2018. So specific relief act provides a special remedy. Like you want, like you enter into an agreement to uh, sell, right? So let us assume that you want to sell your property and you have, so whenever you sell a property, you will do agreement to sell. First, mostly it is agreement to sell. Reason being, nobody has that amount, you know, in one go. Let us say properties of, because when you see the practical aspect, people have to arrange for loan or people have to arrange for funds. So that doesn't happen, overnight. So for that, you need to remember this thing that normally whenever the sale is taken place, it is always preceded by agreement to sell. So agreement to sell, and let us say you do agreement to sell. So which are the two parties for agreement to sell? One is buyer and one is seller. So when I talk about sale in particular, what is the nature of, what are the rights of the seller? What are the rights of the purchaser? That we will come to know when we read Transfer Property Act. And when I discuss Transfer Property Act, then you will come to know that there are four heads in Transfer Property Act. The first head being sale, the second head being lease, the third head had been mortgage, and the last but not the least is the gift. But there is one more topic in Transfer Property Act, that is the charge. So now my priority will be, I'll be taking multiple sessions, especially on my holidays, and we will be trying to cover Civil Law 1. In Civil Law 1, my priority will be to do specific relief act along with Sales of Goods Act, uh, Registration Act. But I think after specific relief act, maybe simultaneously, I will start with you contract as well as transfer property act, because understanding of these acts is very, very important for you guys. So I will request you to have a bare acts with you, and whatever topic we are discussing, you should know. You should revise it on your end. Whatever doubts you have, we can always keep a doubt session. And like some students come to me in my office whenever I am free. You're most welcome. Otherwise, you can always clarify the doubts um, online, or you can just uh, put it in the chat box. So basically, specific act provides eight kinds of reliefs. So when you open up your Bear Act, so what are the eight kinds of reliefs? See, the first is possession of specific immovable property. So what is that? That is section 5 to 6. The second relief is possession of specific movable property. That talks about section 7 to 8. Third relief is specific performance of contract. So that is section 9 to 24. Fourth is rectification of instrument. So rectification means to rectify with the mutual consent, of course. That is section 26. Then we talk about recession of contracts. That is section 27 till 30. Then we talk about cancellation of instrument. That is section 31 to 33. Then most important part of specific relief is the declaration decrees. That is section 34 to 35. So declaration decrees, you see, whenever somebody files a suit for declaration, what is a suit of declaration? This is the basic suit in civil cases when you understand that, let us assume one of you is the owner of a property and the second person is trying to challenge your title, right? So hypothetically, let us suppose there are two sisters in the family. Okay? So let us suppose after the death of the, let us suppose that property was of their father, and let us suppose the mother is also not there. So after the death of the father, the dispute occurs regarding the property of the father. So one sister says it has to come to me uh, as one half because it is by way of inheritance, you know. The second sister says no, it is my absolute property because my father has already done a will in my name. So how will this happen in practical? How will you prove this? To prove this, when you know that there is a dispute among each other, so one of them will definitely go. So let us say the person who says, the sister who says yes, the daughter who says, sorry, I am changing the. So the father had two daughters. So after the death of the father, there is no mother also, mother predeceased father. So property of the father. Now, one of the daughters says it is my property. The other daughter says no, 50% yours, 50% mine, as per Hindu Succession Act. But the let us say the elder sister says no, my father has done a will. So, how will the suit start? The elder sister will go to the court. She will file suit for declaration. So that is why we are talking about declaration decrees, which are described, which are mentioned in section 31 to 33. So she will say no, my father has given me a will. So what she has to do? She will file a suit of declaration on the basis of will dated so and so that I am the absolute owner of the property and my other sister has no right on this property. What will happen then? Suit will be filed, written statement will come, right? If required, replication will come. Then what will happen? Then evidence will be led. How evidence takes place in the court? I assume all of you know evidence takes place by way of affidavit. All right. Then what happens? Then the oral evidence is there, documentary evidence is there, and eventually, you know, the court, there will be leading questions from both the lawyers, and eventually there will be a judgment. So, whenever the judgment is passed, you know, the issues will be framed. What issues means, what are the contentions, what are the questions of dispute among the parties. So, whenever I talk about pleadings, you should know what is civil procedure code, right? What are the basic fundamental principles of pleadings. So this is one of the important main questions. You can write it down. What are the principles of, what are the principles of pleadings, right? So you should know what is the material fact. You should know what is first cause of action. You should know, what are the formal paras in that. So this is all the basic concept of CPC when we understand about pleadings. So you should know what pleadings are. So after that, the seventh mode of relief is declaration decrees I have told you, and the last is preventive reliefs or injunctions. So that is section 36 till 42. So injunctions are very important part of CPC also. You know, whenever you file a suit, you remember there is suit will be filed uh, along with order 39 rule 1. So temporary injunction is described in CPC. But what do you mean by injunction? Injunction means to stop. So whenever you file a main suit in any court of law, especially civil court, you will always see there is always a application under Article 30. Why? Because the person who wants to go to the court approaches the court, that person on the foremost he will want, or he or she will want, that interim stay be granted to that fellow. Why? Because if the interim stay is not, if the interim stay is not granted, then maybe somebody is trying to take a forcible possession. So that kind of a injunction we call temporary injunction, which is described under Order 39, Rule 1 and 2. That is very important part from CPC point of view. But when I talk about specifically that, I am talking about permanent injunctions. I am talking about temporary injunctions, right? I am talking, I am talking about permanent injunctions. I am talking about mandatory injunctions. So that is very, very important part of it, right? Now, coming to the specific relief act, so you should all know that. So I have told you what are the sets of remedies. It is I've just mentioned the set of remedies. Now, when I we talk about specific relief act, the first and the foremost thing is you should know what are the basic amendments which I have carried on 2020. So all these amendments, you see my previous lectures on YouTube. I have discussed these amendments. Bhavna was also part of one of the Bhavna was also part of the lectures, and you can also contribute in that. So the first important thing before reading specific fact is you should understand the nature of it. So always remember specific fact, transfer property act, your partnership act, your registration act, your sales of goods act, your limitation act. They are all based on law of equity. What? They are based on law of equity. What is law of equity? This is also I have discussed in one of the lectures. Listen, equity has principles. What are the principles? Whoever comes to the court comes with clean hands. What does this mean? It means the person who's approaching the court, that person must come with the truth, nothing else. Okay, na? And in UK, we have different courts of equity. But in India, you all should remember, and this is a very important aspect, that court of equity, that civil law is a court of, that civil court is also court of equity in India, right? And that is why these principles of equity are very must. You should not condemn anybody unheard. Like somebody tells you, let us say somebody says something bad about me, right? So you cannot condemn me without hearing my side, right? You should always see it. What a so principle of evidence is. Uh, what is the principle of evidence in civil law? That is preponderance of probability. What a prudent person will think at that time. All right. So all these factors of equity come into play when we read specific effect. So what are the amendments of specific effect? I have already discussed, but the basic concept you should remember is that specific effect before the amendment was at the discretion of the court. ठीक है जी कोर्ट की मर्जी है कोर्ट wants ठीक है discretion है जी we will give otherwise most of the cases damages was impacted. Now see whole purpose of specific effect is not fulfilled. Reason why this act came into existence was to give a specific relief, right? I want that I have to buy that plot only, plot number 2231, sector 15. I don't want to compromise on it. That. If I have done an agreement to sell as a buyer, now seller doesn't want to sell me. No, no. I want that particular. Maybe I have invested on that. I have given you the agreement to sell amount. I have given the earnest money. And I've been planning my financial budget on that since long. So now after taking agreement to sell or you say Bhyana, seller can't say कि नहीं नहीं जिसको बोलो कोई और ले ले मैं इसको damages नहीं. I want that specific one. So that is how the major amendment which has been shifted, which has been taking place in specific leave act is now no more specific leave uh, prayer is discretionary. It is now mandatory. I mean to say there are only few exceptions where court will not grant you specific leave act. Rest in all the scenarios, specific leave will be granted. And what are those exceptions? That also I have briefly told in one of my lectures, but I will just revise it for the sake of it. So now the first thing is that you should go through the amendments which have taken place. Like you should know now. Always remember, like all the acts now, even Evidence Act and even your Transfer Property Act, Registration Act, all your civil laws. Remember, there was amendment which now these all acts are applicable to the states of Jammu and Kashmir also. Why so? Because that came because of the why? Why so? Any could you answer me on that? Because of the Reorganization Act of Jammu and Kashmir, and that was of 2019. So all these acts are now applicable, and they are very much applicable in states of Jammu and Kashmir. So now let us talk about uh, the the amendments. The amendments you could just go through it. There has been amendment of Section 1, I have told you, State of Jammu and Kashmir Reorganization Act. Then there has been amendment of Section 6. Then there has been substitution of new Section 10, amendment of Section 11. So all these amendments I have already explained, I have already discussed in one of the lectures of specifically that. If you find any difficulty, you are free to come and discuss on that. Now let us come to Bear Act, right? Open up section 1. So section 1, you can read on your own. I have seen. Now you see there is amendment of section 1 because subsection 2 says it extends to whole of India, right? So now it is applicable to the states of Jammu and Kashmir also by way of Jammu and Kashmir reorganization. So Evidence Specific Relief Act, Sales of Goods Act, Registration, Transfer Property Act, Limitation, every civil law is not. Now, before going further, the second section is definition clause. So normally in all of Bear Acts, by and large, like Hindu Marriage Act, Hindu Succession Act, even in Transfer Property Act, you will see mostly section 2 is the definition clause. So definition clause means certain terms are defined there and they have to be read as per the terms described in the definition clause. All right. So obligation has been defined, settlement has been defined, trust has been defined, trustee has been defined. So all these four terms which I have just read out, I have already discussed in one of the lectures. Still, you have any issue on that, you are free to ask me the query and I will answer it to the best of my knowledge. And E, always remember those terms which are not defined here, you will automatically uh, see Indian Contract Act, the definition clause, and it will have the same meaning what it had in the Indian Contract Act 1870. So see, most of your laws, Civil Procedure Code and Contract Act, they are of 18th century. 18th century was a Stone Age, so Parliament has not changed this. But now you know there has been amendment in the Indian Evidence Act, there is amendment in CRPC, and there is amendment in IPC. I have discussed this in one of the lecture series in my YouTube channel. You must know what is the name of this new legislations, right? And what are the features of that? You can just go through the YouTube channel and you will find on it. If you find any kind of a difficulty, just let me know. Now I'm coming to section 5. So when I talk about section 5, so before that, I should tell you that section 5 talks about, I have just mentioned earlier that this talks about the possession of immovable property, with section 5 and 6. So before understanding this, I will briefly again repeat that you should know the meaning of immovable property. So you see in your definition clause, there is no definition of immovable property. So how to find a definition when it is not described in your Bear Act? You will see your Bear Act first, whichever Bear Act, whichever subject you are reading, right? Let us assume we are reading specifically that, all right? So here we see that specific effect definition clause. Can you find the meaning of immovable property here? Anybody? Anji, is immovable property described here in the definition clause? No. So it is not defined here. So for this now, you will go to the General Clauses Act. So this is one of the very important acts, what is called is General Clauses Act. Most of the definitions which are not defined in your statutes are generally described in General Clause. But when I see General Clauses Act, I also see Registration Act. But when I compare all the definitions, I find the definition described in the Registration Act is the best definition for immovable. Now, let us read Section 5 from the Bear Act. Yashnoor, will you read Section 5 from the Bear Act, please?
Section 5 Recovery of Specific Immovable Property. A person entitled to the possession of specific immovable property may recover it in the manner provided by Code of Civil Procedure 1908.
Yes. Now, Section 5 is a general section. Now, whenever I talk about the first relief mentioned in specifically that I talk about Section 5 and 6. Okay, na? That is the recovery of possession. I again repeat, recovery of possession of immovable property. So when you read, now this is the heading of the part 2 when you see a Bear Act chapter 1. So heading उसकी यही है ना, recovery of possession of property. ठीक है? So when I talk about recovery of possession of property, we divide in two parts. One is immovable, and in immovable we have section 5 and 6. The second branch is movable, where we have section 7 and 8. Now before moving further, you have just read section 5. So section 5 simply generally understand this is a general remedy. What does this mean? You remedy which is available in civil procedure. Yes or no? So it talks about a general remedy. ठीक है जी? That you go and file a suit in the civil procedure, right? So that is a general remedy. We all know. So specifically, in fact, when it was not in existence, also we were going under CPC and we were filing suit of possession, simply suit of possession under civil procedure. Okay, but now we come to section 6. So section 5 talks about the general remedy as available in CPC. Okay, when we read section 6. Yes, could you read section 6? Please? Yes, could you read section 6? So section 5 talks about a general remedy. So let us first talk about example of section 5. So there is a suit of ejectment. So if somebody is in possession of your property, so what is the general remedy? General remedy is to go to the civil procedure and you file suit under CPC. So one example I will give you will be of I'm opening the bare act of CPC. So you just see order 21. So when I see order 21, execution of decrees and orders. So you simply come to order 35. It talks about decree of delivery of inward property when in occupancy of tenant, that is rule 36 and rule 35. So you see that whenever the remedy is exercised under civil procedure code, that is a general remedy under CPC, right? And you always remember that you will see there is a limitation of 12 years when I see Article 64 of the Limitation Act and 65. So when you see, read the Article 64 and 65, so general remedy is कि 12 सालों के अंदर you can always come to the civil procedure code and you can file a suit of ejectment that you will be plaintiff, right? So what suit you will file? You will file a suit of ejectment that B has taken my property in possession, right, forcibly, and he may be ejected from the court. What will be the limitation in that scenario in general? What will be the general remedy in CPC? Limitation period is 12 years from the date of dispossession. Okay? How I say 12 years? That is by virtue of Article 64 and 65 of the Limitation Act. Clear? Now I come to Section 6. Now the Section 6 talks about the remedy as provided in Specific Relief Act. So ਕਹਿੰਦਾ ਕਿ ਜੇ ਤੁਸੀਂ specifically Section 6 ਦੇ ਵਿੱਚ you want to come and claim the remedy, these are the requisites you have to follow. Requisite means these are the conditions you should follow. What are the conditions? Now let us read Section 6. It says, if any person is dispossessed without his consent, underline dispossessed without his consent, underline, of immovable property, otherwise in due course of law, underline, otherwise in due course of law, he or any person claiming through him may, by suit, recover possession thereof, notwithstanding, notwithstanding का मतलब होता है in spite of any other title that may be set up in such suit. ठीक है? आगे क्या बोलता है? कंडीशंस की गल कर. Section 6 subsection 2 says no suit under this section shall be brought. Now we are talking about the limitation. What is the first clause A? After the expiry of 6 months from the date of dispossession. After the expiry of 6 months from the date of. दूसरी जो कंडीशन कहता है कि specific relief act of specific performance of contract, when you talk about possession of a movable property, that cannot be filed against the government. ठीक है? सरकार के खिलाफ तुसी नहीं पा सकते. That is clause B. That is clause B against the government. ठीक है? And third बड़ा important aspect है, वो कहता है no appeal shall lie from any order or decree passed in any suit under this section, nor shall any review of any such order or decree be allowed. So what is appeal, what is review, we will read in CPC. ये तुसी नहीं इसके खिलाफ जा सकते, but revision पा सकते. What is revision? That is required in CPC. So always remember, revision can lies, right? Supreme Court says yes, revision lies. Civil revision rule लाई करती है, ठीक है? Civil revision High Court पेगी. आगे बोलता nothing in this section shall bar any person from suing to establish his title. देखो, this is very important to understand. Section 6 and 5 only talks about possession. These sections are nowhere talking about the title of the property. देखो, title का मतलब होता है who's the owner of the property. Possession मतलब होता है कि किहदे कोल कब्जा है. And that is why we say possession is 9 points of ownership. ठीक है? सो कदे कंफ्यूज नहीं होना जो टाइटल दी गल आएगी देन वी आर नॉट कमिंग अंडर स्पेसिफिक लीफ एक्ट मतलब सेक्शन 5 एंड 6 ਦੇ ਵਿੱਚ ਜਦੋਂ ਆਪਾਂ ਟਾਈਟਲ ਦੀ ਗੱਲ ਕਰਦੇ ਦੈਨ ਆਪਾਂ ਵੀ ਟਾਕ ਅਬਾਊਟ ਸੂਟ ਆਫ ਡੈਕੋਰੇਸ਼ਨ which I just told you in few minutes ago ठीक है so when you talk about possession of immovable property especially section 5 and 6 because 5 and 6 are talking about immovable property and 7 and 8 talking about movable property so you should always remember that here nobody can stop the other person from establishing his title. So it is only regarding possession. ठीक है ना टाइटल लेने तो उसमें बार कर सकते ठीक है that is written in clause 4 of section 6 that is nothing in this section shall bar any person from suing to establish his title to such property or to recover possession thereof. Okay. I'm just quickly taking a water break and join you in 2 minutes. Okay. Just a minute. My water is finished. Just give me a minute. बाकी समझ आ रहा है आप लोगों को आर यू क्लियर ऑन दिस टिल व्हाट आई हैव डिस्कस्ड ओके सो नाउ just let me grab some water. देखो ये लेक्चर्स आर वेरी इंपॉर्टेंट यू थिंक कि जो ऑनलाइन नोट्स आ जाएंगे जी वो हो जाएगा ना अनलेस until you don't read with me na your clarity will always it is very important to understand and read law the way we do because we all are this is the way and this is the key to have a better understanding just give me 2 minutes. So Bhavna remembers that I have also discussed very important aspect when I was discussing section 5 that is suit based on possessory title, right? So Bhavna, I think you have your notes on that. So could you paste it in the group today so that if you or other candidates who have joined or I want them also to take benefit. So you can write in the chat box. Bhavna, could you share the I've given you can see the chat history also. I've given you the case laws also on possessory title. So could you help me in putting that in the chat? Whenever you can, you get time, you just uh, put it in the group, huh? So that uh, at least the honest candidates who really want to help themselves, it is our duty to make sure it is being facilitated to them. All right. So Bhavna will be putting up those notes in the group probably by the end of the day. Yeah, she has the judgment, so you all can take benefit of that. Yeah, but I'll just go through some brief aspects before moving forward. So first, you should know whenever I talk about possession, you should know the meaning of possession, right? So I think I have already discussed the meaning of possession. So whenever I talk about possession, you should know that possession and ownership, there are two different concepts, right? They are synonyms. Possession means kabza and ownership means malkiyat. कौन है वो owner? Real owner कौन है? ठीक है? ਤੁਹਾਨੂੰ ਕੋਈ ਕਹੇ ਜੀ this is my house, no. Somebody says this is my shop, no. Don't come into क्या पता he is a tenant, क्या पता he is a sublease, ठीक है ना? ਅੱਜਕੱਲ ਕਿਸੇ ਨੂੰ ਇੰਪ੍ਰੈਸ ਕਰਨ ਵਾਸਤੇ ਵੀ ਆਪਾਂ ਕਹਿ ਜਾਂਦੇ ਜੀ ਆ ਦੇਖੋ ਦੁਕਾਨ ਮੇਰੀ ਹੈ ਨਾ, ठीक है? So you as law students, as lawyers, or as legal researchers don't go by hearsay, right? Hamesha you should go behind the real fact. Don't just get carried away. So when I talk about possession, I talk about two things, that is the corpus and the animus. So corpus means the actual power to control, okay? And animus means intention to avail oneself of these powers, right? So these are the two concepts. So what is a juridical possession? You should know about it. I think this I have briefed in one of my lectures also. So always remember that nobody can take law in his own hands, in his or her own hands, because eventually, if you do this, then you will be treated as a person who's abusing the process of law, and stringent actions can be taken against, right? And then you should remember that whenever I talk about possession, you should know there are some Supreme Court judgments which I have shared with you. One of the important judgments was Ramegowda's judgment, uh, that which laid down the attributes for settled possession. So those attributes were A, that the trespasser must be in actual possession of that property over a sufficient period. B, that the possession must be to the knowledge, either express or implied, of the owner without any concealment by the trespasser. So this is important judgment. So then there was another judgment which I mentioned was of Pune Ram. So I'm writing these judgments in the chat box. So you should remember these judgments. One is Ramegowda. This is 2004. Ramegowda. This is 2004 Supreme Court. And the second one is Pune Ram. This is 2019. These are two important judgments, and so you should know about it. I have discussed this. In case you have doubts, you can talk. You can always come with the remedies and we can discuss it, right? So when I was talking about, now I will be talking about immovable property. I've told you it is not defined in specific leaf act. It is defined in section 3, clause 26 of the General Clauses Act. So when you read section 3, clause 26 of the General Clauses Act, it says, it defines it to include land, comma, benefits arising out of land, and things attached to earth or permanently fastened to anything attached to the earth. It includes benefits arising out of lands and things attached to the earth. It includes both tangible and intangible rights, or corporeal or incorporeal rights. So when I read this definition, immediately I will read The definition has been given in the Registration Act. So the most important definition of immovable property is given in the Registration Act, right? So what is that definition? So write down section 2, clause 6 of the registration. Now this is the most detailed definition of immovable property, which you should understand, not from the point of view of specific defect, but also from the point of view of transfer of property. So this definition is very, very important. I want you to go through this definition. I will give you some synopsis on this definition also when I will be sharing you some notes on Transfer Property Act as well as some notes on specific defect. Okay. I have defined the, I will try to post it in the group so that you should have some fair idea about it. Now, the most important part, which Bhavna will also share with you guys, will be regarding the possessory title. Now, this is very, very important to understand because there is a landmark case here of Supreme Court of the, there was a landmark case of Nair Service Society versus Casey Alexander. Now, this is the 1968 Supreme Court case, right? Now, before moving further, I want all of you to understand what is suit of possessory title. Fundamental of fundamental, right? Sorry. So now, suit of possessory title, you should remember that it's very, very important, and I have discussed it in one of the videos also. So when I talk about suit of possessory title, you should remember that Supreme Court has said that in a case the rightful owner does not come forward within the period of limitation, his right is lost, and the possessory owners acquires the absolute title. So here, what you should understand, you know that person is in the possession of the property. Still that, still knowing that you are closing your eyes and you are being a mute spectator, then obviously that possession will automatically, the person plaintiff who was in de facto possession, he will be entitled to remain in possession, and and eventually he acquires the absolute title in that. Now here I am talking also of adverse possession, which is one of the important aspects of your statute. So right now, for you to understand is what is suit of possessory title. Already this has been shared with the judgments in the group. So I think Bhavna will do it in the evening. You just go through this judgment and then we will talk in detail if you have any doubts. I will touch the topic of possessory title again because topic of possessory title vis-a-vis person adverse possession. When I talk about person as an adverse possession, there is a very important case law of Ravinder Kaur Garewal versus Manjeet Kaur. Now, this is those are only the case. Yeah. So this case also I will discuss in detail. Okay? Because here Supreme Court has discussed the concept of adverse possession in detail. There were two legal prepositions laid down in front of the Supreme Court. The first was, can a person in reverse possession can file a suit of declaration and permanent injunction? And the second legal preposition was, can there be tacking of time period of, so tacking का मतलब होता है fixing. Can there be tacking of time period of 12 years in respect of a divorce possession? So both the answers were answered by the Supreme Court in the positive way. But here I need to discuss in detail this judgment. Bhavna, if we have not discussed this judgment in any of the lectures, you let me know right now so that I can elaborate on this judgment. Have we discussed on this earlier? Okay, we have discussed it. So this note, you have the notes of this also with you, I guess. Will you put it on the group, Hannah? In the evening, probably? ठीक है, very good. So these aspects, yeah, ठीक है. Today or tomorrow, she will put. So these aspects of section of this chapter one in context to recovering possession of property, I'm talking about immovable property as of now, are very, very important for you to know, because these are the very important aspects, and you can always be asked about, you know, these important facets of law. There can always be a preposition, and you will be required to comment on that preposition, right? So for that, you need to have a basic knowledge regarding suit of possessory title. You know? What is the impact of suit of possessory title vis-a-vis suit of adverse possession? Because suit of adverse possession also we study later part of it, but I want to discuss the main updates on that now. So this is very, very important. And moving further, when I see section 6, I've just read with you that from the Bare Act only, when you read section 6, one thing is very clear, we are talking about the specific remedy. And what here you have to take care of, that it has to be filed within, after this, within the 6 months from the date of disposition, right? So 6 months period is very important to understand. Now, so when I talk about section 6, you see, section 6 is based on two broad principles. The first principle is that this disputed right should be adjudicated in due course of law. Okay, that is, you cannot take law in your own hands. And the second principle is that the existing possession of immovable property of person should be protected, notwithstanding any other title that may be set up in the suit against it. So the objective of this provision is to protect self-help and to discourage people to take law in their own, right? So you can always remember that this section 6 provides for a summary remedy. Okay? So, um, so here, whenever the suit is filed under section 6, you will all remember the courts will not go into the question of title. Again, the courts will not go into the question of titles if the suit is filed under section 6. So when I summarize all this, so in order to take relief under section 6 of the specifically fact, following points should be taken into consideration. What are those points? You see there at first will be the plaintiff is dispossessed of immovable property. इसके अंदर लिखा हुआ, I have made you underline also. Second is the plaintiff was dispossessed without his consent. Always remember, plaintiff was dispossessed without his consent. So let me take a hypothetical example. Let us say the landlord wanted to do the marriage of his daughter, ठीक है? और tenant ਨੂੰ ਕਹਿੰਦਾ ਭਾਈ ਸਾਹਿਬ ਮੈਂ ਕੁੜੀ ਦੀ ਸ਼ਾਦੀ ਕਰਨੀ ਹੈ, ਸੁਣਿਆ ਤੁਸੀਂ ਥੋੜੇ ਦਿਨਾਂ ਵਾਸਤੇ ਡਲਹੌਜ਼ੀ ਜਾ ਰਹੇ ਹੋ, ਤੁਸੀਂ ਮੈਨੂੰ ਜਰਾ ਉਹ ਦੇ ਦਿਓ ਯੂਜ਼ ਕਰਨ ਵਾਸਤੇ, ਠੀਕ ਹੈ? ਉਹ ਕਹਿੰਦਾ ਵੀ ਲਓ ਗਾਲੀ ਕੋਈ ਨਹੀਂ, ਆ ਲਓ ਜੀ ਯੂਜ਼ ਕਰੋ। ਉਹ ਜਾਂਦਾ ਡਲਹੌਜ਼ੀ ਮਜ਼ੇ ਦੇ ਨਾਲ ਹੈ, ਇੱਥੇ ਬੈਂਡ ਵਾਜੇ ਦੀ ਰਾਤ ਆ ਜਾਂਦਾ, ਠੀਕ ਹੈ? मैरिज इज डन विद ऑल pomp एंड शो। भाई साहब आगे डलहौजी तो घूम के, तो मकान वाले कहते भाई साहब मैं आ गया वापस। कहते जी फिर? कहता जी चाबियां दो। लैंडलॉर्ड कहे चाबियां किहड़ियां चाबियां, मैं नहीं देनी। नाउ कैन इन दिस केस tenant approach the court under section 6 of specific fact? Answer me yes or no, you can write in the chat box. Can the tenant approach the court under section 6 of specific fact? Now beta ठीक है, well attempted. What about you? Others also reply. Others also chat, type in the chat box. Yes, Bhavna, you also chat, type in the chat box. So, देखो, what are the conditions of section 6? Yes, first is the plaintiff is dispossessed of his immovable property. Second condition के लिए खाई है मैं, the dispossession was without his consent. So here, tenant can't go under section 6 of specific fact. He can take other remedies. कि देखो जी मेरा रेंट डीड है, आ मेरा लीज एग्रीमेंट है, रजिस्टर्ड है, इन्हें मैनू धक्के नाल मेरे नाल ऐ कीता, धक्के नाल कब्जा ले लिया. He can go and take whatever remedy. Let us say there is a remedy in the Rent Control Act, he can use that. But under section 6 he cannot take the remedy. Why? Because the element of dispossession was with his consent, right? And section 6 says that this plaintiff was dispossessed without his consent. Without his consent. Am I clear? समझ आया? Okay, शाबाश. ਹੁਣ थर्ड पॉइंट ਦੀ ਗੱਲ ਕਰਦੇ हैं कि dispossession was otherwise then in due course of law. ठीक है ना? So and fourth point आ ਜਾਂਦਾ ਇਹਦੇ ਵਿੱਚ. So dispossession was other than in due course of law. ठीक है ना? ਧੱਕੇ ਨਾਲ possession ਕਰ ਲਿਆ, ਤੁਸੀਂ ਬਾਹਰ ਗਏ ਧੱਕੇ. And fourth आ गया जी, suit has been brought within 6 months from the date of dispossession. This is also a condition. And the last is dispossession was not by the government. So, however, it does not include any statutory corporation. So, this here you should remember, these are the important conditions when I talk about section 6. So when I talk about, when you see section 6, it says if any person, now when I talk about any person doesn't mean he is the servant. Any person doesn't mean he's the agent. Any person doesn't mean he's the, you know, employee. So any person does not include persons, right? Right? So term possession means juridical possession. So what is juridical possession? That you will answer me. I have already discussed with you. So always remember a possession. So, but always remember possession of mortgagee, tenant, trespassee is a settled possession and it's considered as a juridical possession. So what is a juridical possession? Juridical possession means a possession of a mortgagee, a possession of a and trespasser in settled possession. Sir, what is trespasser in settled possession? Trespasser in settled possession is where the owner was mum. ਉਹਨੂੰ ਪਤਾ ਸੀ ਇੰਨੇ ਸਾਲਾਂ ਤੋਂ ਬੈਠਾ ਹੈ, ਲਿਮਿਟੇਸ਼ਨ ਦਾ ਟਾਈਮ ਖਤਮ ਹੋ ਗਿਆ, 12 ਸਾਲ ਹੋ ਗਏ, ਉਹਦੇ ਰਾਈਟਸ ਫਰੈਕਟੀਫਾਈ ਹੋ ਗਏ ਬਾਈ ਵੇ ਆਫ ਐਡਵਰਸ ਪੋਜੀਸ਼ਨ, ਉਹਨੂੰ ਕਹਿੰਦੇ ਆ ਆਪਾਂ trespasser in settled possession. That is why I told you it is a very important aspect for you to understand what is root of possessory right. ਇਹ ਬੰਦੇ ਨੂੰ ਆਪਾਂ ਕੀ ਕਹਿੰਦੇ ਆ, ਇਸ ਪੋਜੀਸ਼ਨ ਨੂੰ ਅਸੀਂ ਕੀ ਕਹਾਂਗੇ ਲਾਅ ਦੇ ਵਿੱਚ, ਇਹਨੂੰ ਆਪਾਂ ਕਹਾਂਗੇ juridical possession. Again, what we call it? Juridical possession. But possession of employee, possession of servant, and possession of appointee, that is not covered under the aspect of section 6. उसका मतलब थोड़ा अपना ही करना, ठीक है? Am I clear on this? Clear? You can write in the chat box. समझ आया? Correct. So now you should remember कि ਇਹਦੇ ਵਿੱਚ ਹੁਣ ਆਪਾਂ ਗੱਲ ਕਰਦੇ ਹਾਂ ਜੀ, if any person, हाँ, so section 6 ਦੇ ਵਿੱਚ amendment ਵੀ ਹੋਈ ਸੀ, है ना? I told you. So ਜਿਹੜੀ amendment ਇਹਦੇ ਵਿੱਚ main amendment ਇਹ ਹੋਈ ਹੈ ਕਿ when you read section 6 ਨਾ, if any person is dispossessed without his consent of immovable property otherwise in due course of law, he, ਪਹਿਲਾਂ ਕੀ ਸੀ ਕੱਲਾ, it was earlier it was only he or any person claiming through him ਸੀਗਾ, ਉਹਨਾਂ ਨੇ ਐਡ ਕਰਤਾ he or any person through whom he has been in possession, or any person through whom he has in possession means, for instance, now in we have to elaborate. So if any person is dispossessed without his consent of immovable property, otherwise in due course of life, he or any person through whom he has been in possession, claiming through him, may by suit recover possession thereof, in spite of any other title that may be set up in suit. So, पहली गल तो याद रखो कि जी a person who was actually dispossessed, ठीक है? So these are the categories when you say that persons who are entitled to recover possession. ठीक है? Person who was actually dispossessed, he has the right to take possession. ठीक? One amendment आ गई 2018 च. One amendment says a person through whom he has been in possession. A person through whom he has been in possession. For example, a tenant is in possession through his landlord. Understood? Thus, in eventuality of a dispossession of a tenant by a third party, both landlord and tenant would be entitled to institute a suit under section 6 of that. ਇਹਨੂੰ ਹੁਣ ਥੋੜਾ you should understand it. What does this mean? ਹੁਣ suppose ਕਰੋ ਵੀ tenant ਗਿਆ ਹੋਇਆ ਬਾਹਰ, ਠੀਕ ਹੈ, ਤੁਸੀਂ ਗਏ ਬਿਜ਼ਨਸ ਗਏ ਜਾਂ ਕਚਹਿਰੀ ਆਇਆ ਮੈਂ ਕੰਮ ਕਰਨ ਵਾਸਤੇ, ਪਤਾ ਚੱਲਿਆ ਜੀ ਜਿਹੜਾ ਟੈਨੈਂਟ ਦਾ ਏਰੀਆ ਸੀ ਆ ਕੋਈ ਮਾਫੀਆ ਮੰਡੀਰ, ਕੀ ਕਹਿੰਦੇ ਉਹਨੂੰ, ਮਾਫੀਆ ਮੰਡੀਰ ਹੈ, ਮਾਫੀਆ ਮੰਡੀਰ ਵਾਲੇ ਆਏ, ਉਹ ਕਬਜ਼ਾ ਕਰਕੇ ਬਹਿ ਗਏ, ਮੈਂ ਆ ਕੇ ਦੇਖਿਆ ਇਹਦਾ भांडे मंजे चक्की करते हैं ना। नाउ व्हाट शुड आई डू? तो भाई जे टेनेंट बाहर गया मैं भी सूट पा सकता हूं अंडर सेक्शन 6 ਦੇ ਵਿੱਚ बिकॉज इवेंचुअली द टाइटल इज इवेंचुअली दैट पर्सन इज हैविंग पोजेशन थ्रू मी। ਉਹਨੂੰ ਆਂਦੇ ਆਂਦੇ 5 ਦਿਨ ਲੱਗ ਜਾਣਗੇ। ਸਪੋਜ਼ ਕਰੋ ਜੀ ਉਹ ਤਾਂ ਵਿਚਾਰਾ ਉਹ ਕਰਨ ਗਿਆ ਜੀ ਆਪਣੇ ਪਿਓ ਦਾ ਸ਼ਰਾਧ ਕਰਨ ਗਿਆ ਹੈ ਆਪਣੇ ਪਿੰਡ ਗਿਆ। ਉਹ ਪਤਾ ਚੱਲਿਆ ਅੱਜ ਕੱਲ੍ਹ ਭਾਈ ਸ਼ਰਾਧ ਚੱਲ ਰਹੇ ਹਨ। ਉਹ ਪਿੰਡ ਗਿਆ ਜੀ ਉੱਥੋਂ ਆਂਦੇ ਆਂਦੇ ਨੂੰ ਟਾਈਮ ਲੱਗ ਗਿਆ। ਦੈਨ ਵਾਟ ਵਿਲ ਹੈਪਨ? ਹੋਣਾ ਕੀ ਹੈ ਜੀ ਕੁਝ ਨਹੀਂ ਮੈਂ ਕੇਸ ਪਾਵਾਂ ਉਹ ਵੀ ਕੇਸ ਪਾ ਦੇਗਾ। ਉਹਨੂੰ ਮੈਂ ਕਹਾਂਗਾ ਹਾਂ ਭਾਈ ਇਹ ਬੰਦੇ ਆ ਗਏ ਹੈ ਮੈਂ ਸੈਕਸ਼ਨ 6 ਦੇ ਵਿੱਚ ਕੇਸ ਪਾ ਰਿਹਾ ਹਾਂ ਭਾਜੀ ਪਾ ਦਿਓ ਮੈਂ ਵੀ ਆ ਉਹ ਕੀ ਕੈਨ ਆਲਸੋ ਬੀ ਨੈਸੈਸਰੀ ਪਾਰਟ। ਸੋ ਦਿਸ ਇਜ਼ ਦ ਬੇਸਿਕ ਅਮੈਂਡਮੈਂਟ। ਅੱਗੇ ਕੀ ਹੁੰਦਾ ਸੀ ਆਈ ਹੈਵ ਟੂ ਨਾਓ ਥਰੂ ਹਿਮ ਇਹਦੇ ਲਿਖਿਆ ਨਾ through whom he has been in possession. Clear? This aspect of amendment is clear. देखो मैं तो बड़ी practical example देना समझाया. Is it clear to you? Yes or no? Yes, भावना. Is it clear? Yushnur clear है? ठीक, शाबाश। इन्हों तुसी चंगी तरह पढ़ना है ठीक है। तो लास्ट पॉइंट ਇਹਦਾ ਆ ਜਾਂਦਾ ਹੈ any person claiming through him. So पहला तो आ गया मैं ਤੁਹਾਨੂੰ एग्जांपल देता लैंडलॉर्ड टेनेंट ठीक है। पहला मैं एग्जांपल ਤੁਹਾਨੂੰ ਦਿੱਤਾ through whom he has been possession। ਇਹਦਾ एग्जांपल मैं देता जी लैंडलॉर्ड टेनेंट। The second example is or any person। So or any person through him ਇਹਦਾ ਮਤਲਬ ਕੀ ਹੋਏਗਾ? ਨਾਰਮਲੀ ਸੈਕਟਰ 17 ਤੁਸੀਂ ਜਾਂਦੇ ਹੋ ਸ਼ਾਪਿੰਗ ਕਰਨ ਹੈ ਨਾ ਜਾਂਦੇ ਹੋ ਸੈਕਟਰ 17 ਦੇ ਵਿੱਚ। ਹੁਣ ਰਿਐਲਿਟੀ ਆਫ ਸੈਕਟਰ 17 ਇਹ ਹੈ ਕਿ ਵੀ ਬੜੇ ਪੁਰਾਣੇ ਟੈਨੈਂਟਸ ਬੈਠੇ ਹੋਏ ਉਹ ਰੁਪਈਆ 100 ਵੀ ਨਹੀਂ ਦਿੰਦੇ ਹੋਣਗੇ 200 ਵੀ ਨਹੀਂ ਦਿੰਦੇ ਹੋਣਗੇ ਉਹ ਅੱਗੇ ਕੀ ਕਰਦੇ ਆ ਸਬ ਲੀਜ਼ ਕਰ ਦਿੰਦੇ ਕੀ ਕਰਦੇ ਆ ਸਬ ਲੀਜ਼ ਵਿਚ ਇਜ਼ ਐਕਚੁਅਲੀ ਅਗੇਂਸਟ ਦ ਪ੍ਰੋਵੀਜ਼ਨਸ ਆਫ ਰੈਂਟ। ਬਟ ਜਦੋਂ ਅਸੀਂ ਕੇਸ ਪਾਉਂਦੇ ਹਾਂ ਜੀ ਦੇਖੋ ਟੈਨੈਂਟ ਨੇ ਐ ਕੀਤਾ ਉਹ ਕਹਿੰਦੇ ਜੀ ਨਹੀਂ ਨਹੀਂ ਅਸੀਂ ਸਬ ਲੀਜ਼ ਸ਼ੁਰੂ ਕੀਤਾ ਇਹ ਤਾਂ ਲਾਇਸੈਂਸੀ ਬੈਠਾ। ਨਾਓ ਦੇਰ ਇਜ਼ ਅ ਡਿਫਰੈਂਸ ਬਿਟਵੀਨ ਲੀਜ਼ ਐਂਡ ਲਾਇਸੈਂਸੀ ਵਿਚ ਵੀ ਵਿਲ ਡਿਸਕਸ ਵੈਨ ਆਈ ਡੂ ਟ੍ਰਾਂਸਫਰ ਪ੍ਰੋਪਰਟੀ ਐਕਟ along with the head of lease when I do on the transfer property act। ਠੀਕ ਹੈ। तो ਕੀ ਹੁੰਦਾ ਹੈ ਕਿ ਸਪੋਜ਼ ਕਰੋ ਤੁਸੀਂ ਕਿਰਾਏਦਾਰ ਹੋ ਤੁਸੀਂ ਅੱਗੇ ਬੜਾ ਸੌਖਾ ਕੰਮ ਹੈ ਮੈਂ 100 ਯੂ ਹੈਵ ਟੇਕਨ ਅ ਸ਼ਾਪ ਫॉर 200 ਰੁਪੀਜ਼ ਅੱਗੇ ਤੁਸੀਂ ਕਿਰਾਏ ਤੇ ਦਿੱਤੀ ਹੈ 1 ਲੱਖ ਦੀ ਕਿੰਨੀ ਮੌਜ ਹੈ ਕੁਝ ਨਹੀਂ ਕਰਨ ਦੀ ਲੋੜ ਉਹ 1 ਲੱਖ ਰੁਪਏ ਦੇ ਰਿਹਾ ਓਨਰ ਨੂੰ ਕੁਝ ਅਸਲੀ ਲੈਂਡਲॉर्ड ਨੂੰ ਕੁਝ ਮਿਲਦਾ ਹੀ ਨਹੀਂ ਪਿਆ। ਵਾਟ ਵਿਲ ਹੈਪਨ ਨਾਓ ਸਪੋਜ਼ ਕਰੋ ਉਹ ਉਹਨੂੰ ਵੀ ਕਿਸੇ ਨੇ ਜਿਹੜਾ ਮੈਂ ਅੱਗੇ ਸਬ ਲੀਜ਼ ਕੀਤਾ ਸੀ some trespassers come take forcefully possession then in that case also any person ਦਾ ਮਤਲਬ ਹੈ ਕਿ ਉਹ ਜਿਹੜਾ ਸਬ ਟੈਨੈਂਟ ਹੈ ਉਹ ਵੀ ਆ ਕੇ ਸੈਕਸ਼ਨ 6 ਦੀ ਰੈਮਡੀ ਲੈ ਸਕਦਾ। Clear? Yes, clear to all of you? चलो ठीक है ओके। नाउ तो नो रेमेडी अपील है बट ਤੁਹਾਨੂੰ ਯਾ ਪਤਾ ਹੋਏਗਾ ਕਿ ਰਿवीजन इज मेंटेन ठीक। सुप्रीम कोर्ट says yes revision is maintained। So now last but not the least you should remember these aspects। What are the aspects? First, who can avail remedy under section 6? I have told you trespasser in settled possession। Second, licensee। just hold on। So trespasser settled possession. Okay, they can all avail remedy under section 6. Licensee. So then whenever I talk about tenants, you should remember these following 2 points. So, so what I said was that, so you can just write down whenever there is a doubt regarding a tenant. So I've told you that tenant can also files under section 6, right? When I've given you 2 examples. First example was he had given the keys with the consent. वो section 6 नहीं आ सकता. But हाँ, some third party takes his area under his possession and then he can file under section 6 because here he had not consented. ਉਹਨੂੰ ਪਤਾ ਨਹੀਂ ਸੀ ਉਹ ਬਾਹਰ ਗਿਆ ਸੀ third party ਆ ਗਈ ਤੇ ਕਬਜ਼ਾ ਕਰ ਲਿਆ ਠੀਕ ਹੈ. So just remember these 2 points. The first point is तो tenant ਦੇ ਦੋ aspects हैं. ਪਹਿਲਾ ਹੈ ਕਿ ਜਦੋਂ lease deed ਜਾਂ ਉਹਨੂੰ rent deed ਕਹਿੰਦੇ ਆ when it is valid. So no problem in that. He can file under section 5 also. He can file under section 6 also. But the question is, what if the lease period is expired? Then can tenant come under the purview of section 6? Then I have told you, if the tenant is able to prove his settled possession. What? His settled possession. So settled possession, that is the juridical possession, if he can prove, then he can file under section 60. I've been there. He is known to him. He has not evicted me. He has not put any case of eviction, and I am there for so many years. Okay. Then also he can file a case under section 6, which in the practical aspect it is not possible. है ना? Obviously, tenant का lease period खत्म हो गया तो landlord को क्यों रहने दोगे? ठीक है ना? He will say भाई जाओ आप और give me the latest rent. So the example which I told you, the landlord, tenant knows somebody forcibly has dispossessed from the property, then landlord can also file a suit against that trespasser. Now, this was held in one of the judgments of 2010, right? So I can give you the name of the judgment. The name of the judgment is Sadashiv versus Anita. Those are the Supreme Court. Now, coming to section 5 and 6, so let us see what are the differences between section 5. So, first, the basis of remedy. Section 5 is a remedy under CPC, whereas section 6 is a specific remedy under section 6. Okay. So, when I talk about the procedure, when I talk about section 5, civil procedure code has to be followed. Whenever I talk about section 6, summary remedy to a person has to be availed. That is when he is dispossessed within the 6 months of his dispossession. So always remember that civil suit can also be maintainable. That now I have told you the 2 remedies. One is section 5 under CPC. That is the general remedy. The second remedy is under this statute, that is section 6. ठीक है ना? Suppose करो तुझे section 6 ਦੇ ਵਿੱਚ case ਪਾਇਆ and ਤੁਸੀਂ ਹਾਰ ਗਏ. But that doesn't bar you to file a case under section 5. So if you avail special remedy that is available in section 6, and God forbid you if you lose the case, then there is no bar for the plaintiff to approach the general remedy, that is by way of section 5. Clear? So whenever I talk about section 5, full-fledged suit ਚੱਲੂਗਾ ठीक है. Question title ਵੀ ਆ ਸਕਦਾ ਉਹਦੇ ਵਿੱਚ ਕੱਲ ਨੂੰ ਜਦੋਂ section 6 ਦੀ ਗੱਲ ਕਰਾਂਗੇ it will only talk about possession. So when talk about section 5, ਉਹਦੇ ਸਾਰਾ ਕੁਝ ਹੀ ਹੁੰਦਾ, appeal ਵੀ ਹੁੰਦੀ ਹੈ, review ਵੀ ਹੁੰਦਾ ਹੈ. But section 6 ਦੇ ਵਿੱਚ no appeal, review, only revision is allowed. Then you should always remember that section 5 is available against anybody, even against government also. But when I talk about government, CPC says there is one section in CPC. Now you will tell me which is that section. It says कि जी को notice जरूर serve करना होगा, ठीक है? So when I talk about section 5, देखो section 5 ਦੇ ਵਿੱਚ that judgment normally operates as a res judicata. और possession की ਗੱਲ करते हैं, that will not operate as res judicata, ठीक है? So these are the important aspects. So I will also talk about adverse possession. I have already talked about adverse possession with you. Okay. So I think for today, section 5 and 6, along with the notes which I have already given you or shared in the previous lectures, you just go through it because section 5 and 6 is very, very important, especially section 6. On the next lecture, I will discuss with you will be 7 and 8. Bhavna, till which sections we have covered in previous lectures? I think we did the 7 and 8 also. चलो कोई बात नहीं अब section हाँ so we will do section 7 and 8 in the next lecture along with other sections. When I talk about section 10 in particular, I will also discuss with you that in which cases uh, contract can be specifically enforceable. So what are those sections? When I talk about specifically enforceable, those are basically 4 sections, very, very important: section 10, section 12, section 13. So section 10, section 11, section 12, section 13. These are the 4 sections in which contracts specifically enforced. You see the Bear Act also. Open up the index part. Sorry, the content part. Content part, there is the co-specific performance of contract. Section 10, specific performance in respect of contracts. Cases trust, 12वां आ गया, 13वां आ गया, part of contract, 12वां आ गया, 13. So basically, these 4 sections talk about specific cases where specific performance of contract can be specifically enforced. Any exceptions की हैं, वो दूसरे आगे देखोगे, section 14 की गल करांगे, section 14A की गल करांगे. So, good for today, I think, on specific leaf act, and I'll be also starting simultaneously one of the more subjects that we will discuss. Okay, okay then, and that's for today. God bless you, and revise what we have done. Thank you.